May I please, Your Lordship?
Yes, please.
Lordship, I beg to mention for item number 12, Your Lordship.
Item 12.
Yes. On behalf of Vikram Devnath. Your Lordship, he's out of station.
Vikram Devnath is for the appellant,
Yes.
Mr. So-and-so. Makes a mention on behalf of Mr. V. Devnath, the learned counsel for the appellant, and seeks adjournment of the case for?
Sir, Your Lordship, 4 weeks.
No, 4 weeks. For
Lordship,
2 weeks.
his wife is on medical treatment, Your Lordship, in Delhi, so he's out of station. So he might take time.
For 4 weeks, on the ground that the learned counsel's wife is undergoing medical treatment at Delhi. Listed after 4 weeks.
Obliged, my Lord. Lordship, I also beg to mention for item number 17 to 20, Lordship, on behalf of L. Likase. Lordship, he has taken leave, Lordship. It has been reflected in the cost list.
His leave is up to 8.
Yes, Lordship. 10.
Yes, government?
Yes, Your Lordship.
We'll list it next week. This is a small matter.
Okay, Lordship, Lordship.
Lordship.
Okay?
Lordship.
You are mentioning on behalf of Mr.
L. Likase.
L. Likase. Mr. So-and-so makes a mention on behalf of Mr. L. Likase, the learned counsel for the respondent, and seeks adjournment of the case after a week. Listed. What is next Tuesday or Wednesday?
15.
Listed on?
15.
Okay.
15.
Is it okay for both of you?
Lordship.
Listed on 15 to 2023. Okay.
Obliged, my Lord.
May I please, Your Lordship? I beg to mention item 3, 4, 5, and 9. I'm appearing on behalf of AZO, Your Lordship. Kindly this matter will be listed.
For this admission, let us see what was the last order passed.
Your Lordship, I'm not engaged in this case.
It's all right. It's all right. We'll accommodate.
I don't
we'll
have to
accommodate
brief
you
us.
prayer, but
Okay, no problem.
let us see what was the last order passed.
Yes, Your Lordship.
Okay.
Okay.
May I please, my Lordship?
Yes, please.
I beg for item number 16, WA12 2022.
16.
Yes, sir.
Yes.
I, on behalf of Joshua Shiki, my senior.
Okay.
Sir, since
Mr. So-and-so submits that Mr. Joshua Shaki, the learned counsel for the appellant, is indisposed, and therefore seeks adjournment of the case after 2 weeks, listed accordingly. Okay.
May I
Yes,
please,
ma'am.
my lords?
Yes, ma'am.
Yes, I beg to mention item number 13 and 14, Your Lordship.
13 and 14.
Yes, Lordship. On behalf of the counsel for the appellant,
Who is the counsel?
Mr. Sinti Younger.
Okay, MS so-and-so makes a mention on behalf of Mr. Sinti Younger, the counsel for the appellant, and seeks adjournment of the case
Lordship, 2 weeks.
after 2 weeks, listed accordingly.
Operation.
For motion, item 1, PIL 1, 2023.
May I please, Your Lordship?
Yes, please.
The petitioners before your lordships are representative of the Gauhati Midas 2 Land Damage Victims Association, Takabama, 60 section and affected landowners union. So,
Please bring the mic. Yes.
yes, sir. Am I audible? Yeah. The petitioners before your lordships are the representative of Gauhati Midas 2 Land Damage Compensation Associations, Lordship. So,
Gayatri Mitas?
yes, Lordship. There was a similar order which the judgment order has been passed.
No. Who are the petitioners?
Petitioners are the representative of Gauhati Midas Land Compensation Damage Associations.
Oh,
Associations
Damage
of-
Land Compensation
yes,
Association.
Yes,
Okay.
this is of different area, Lordship.
Okay.
The earlier BIL which was disposed of was confined only to the Peck district area.
Okay, and
But
this
now
is confined?
this is from Chakabama area, Lordship.
Okay. Chakabama area.
Yeah, Lordship. Chakabama Road, Chakabama Zinibodo Road area. If I may take your lordships to
You are representing The entire landowners or only
Yes, entire landowners.
170?
Entire landowners of Chakabama village areas.
Okay. So the aggrieved person consists of 170 landowners.
177, yes. Lordship.
Okay. But you are also for the general public of that two laning.
Yes, Lordship.
Okay.
I'm confined only to one area, if I may take your
But
Lordship.
that project has stopped.
Pardon?
That project has stopped.
Yes, Lordship.
It has stopped.
Yes, Lordship.
Whether actually any assessment has been carried out
Assessment has been carried out.
by the
If I-
government?
Yes,
By who?
by the joint venture, by government and publics. If I may take your Lordships to page number 30 of the pleadings.
30.
Yes, Lordship.
Okay.
There is an abstract column in column 4, Zinipodo Chakabama Road. Under here, there is Peg, Zinipodo, and Kohima. I'm concerned with Kohima, volume 4C. Regarding the earlier BIL number 9,
Just wait. Volume 4, C.
C, yes, Lordship.
Zinaboto Chakabama Road.
Zinipodo Chakabama Road. Earlier, BIL number 9 was confined to this Fake Futuro Road and Zinipodo Chakabama. Under Fake Futuro Road, this volume 3 was concerned with that matter, and volume 4A and B. Oh, no, sorry. Only volume 4A. Volume 4A and volume 3 are concerned with the BIL 9,
The
which was
volume-
disposed of.
Volume, you are now concerned with
Volume
serial number
4C.
4?
Serial number 4, Kohima, volume 4C.
Volume 4C.
Yes, Lordship.
Okay. So, the compensation has been assessed to, what is it, 4 crores?
Yes.
70 lakhs?
4 crores, 70 lakhs.
9,790.
9,790. Yes,
And
Lordship.
this is for those 170
Yes, Lordship.
aggrieved
If I-
landowners.
Yes, Lordship. If I may take your Lordship to Annexure 12, page 79.
Annexure 12?
Page 79. These are the beneficiaries.
Annexure
Annexure 12, Lordship, page 79.
Annexure 12, page 79.
Yes, Lordship.
Oh, page 79.
This is abstract chart for
Just wait,
compensation
just
to children
wait.
properties damage. Letter dated 27 February 2017.
So these are the list of the 177 aggrieved landowners.
Yes, Lordship. Same and similar case has been disposed of white judgment and order dated.
You confine to your case. You
Lordship.
confine to your case.
Lordship.
When has the project stopped?
Due to the intervention of, by the order of the Honorable Supreme Court
No, when?
in 2017, Lordship.
So it's completely stopped. Completely
Actually,
stopped.
actually, this Midas Kitris, their contract has been stopped, and NHIDCL has taken over the project.
Okay, now it is done under the supervision of,
Under the supervision of NHIDCL.
NHIDCL.
Yes, Lordship.
and who is the contractor?
That-
NHIDCL is an authority. Correct?
Yes, Lordship.
So who is the contractor? The petitioners are the representatives. No. The petitioner represents. the Gauhati Midas 2 Land Damaged Victim Associations, Chakabama Sidzu Section, and Affected Land Owners Union Sakabama Village, Goma District, Kohima, Nagaland. Whose land, properties, and houses, etc., were damaged. During the two laning of Longland dash Changtungya Road, Koma Tamlu dash Mon dash Tamlu dash Merangkung Road, Koma Hek dash Futsuro Road, and Zinaboto dash Chakabama SARDP dash NE within bracket phase A, comma. The petitioner, more particularly, represents the aggrieved landowners numbering about 177 families whose land, properties, and houses were damaged along the Zinabuto Chakabama Road under the administrative jurisdiction of SDO within bracket C DEV, IC KSO Charge Circle under the Deputy Commissioner, Kohima. It is the case of the petitioner that although the government has ascertained and assessed the compensation payable to the aggrieved landowners, no action so far has been taken to release the compensation to the aggrieved landowners. Being aggrieved, the petitioners representing the landowners are before this court. Issue notice to the respondents, returnable within 4 weeks. Yes, ma'am, you are representing?
Respondent number 2, 5, 6, 8, 9, and 10.
2,
5, 6, 8, 9, and 10.
2, 5, 6, 8, 9, 10. Since Ms. A. Ayemi, the learned government advocate, represents the respondent number 2, 5, 6, 8, 9, and 10. No formal notice need be issued to the said respondents. Stop. The learned counsel for the petitioner shall, however, serve requisite copies of the petition to the learned state council within a period of
Within today, Lordship.
within a period of 2 days
2 days, 2 days.
from today. Stop. Insofar as the other respondents are concerned, the learned counsel for the petitioner shall take steps for service of notice on the said respondents by registered post with AD within a period of
2 days, Lordship.
2 days from today. Listed accordingly.
For admission, item 2, read appeal 12, 2018.
None appears for the parties. Listed again on, when is the next Wednesday? Listed again on?
15.
Yes, 15 to 2022.
Item number 3, 4, and 5, WPC 261, 2021.
Your
Yes.
Lordship, I'm appearing on behalf of ASO, Your Lordship. Kindly this matter may be adjourned for 2 weeks for item 3, 4, and 5.
3, 4, and 5.
Yes, Your Lordship.
Okay? Mr. So-and-so makes a mention on behalf of Mr. Ezo, the learned counsel for the respondent. Respondent number?
For petitioner, Your Lordship.
No, petitioner is Mr. Tongpok.
Yes, petitioner in item 4. No. In item 5. And respondents in item 3 and 4, Your Lordship.
Yes, what was the loss? Mr. Ezo, learned counsel for the petitioner in item number 5, and the learned counsel for the respondent in item number 3 and 4. On the ground that, yes, what is the reason?
Your Lordship, he went for the scrutiny, Your Lordship. He is out of station.
On the ground that Mr. Ezo is out of station. Listed after 2 weeks as prayed for.
Much obliged, Your Lordship.
Item number 6 and 7, IA Criminal 22, 2022.
Yes, may I please, my lords.
Yes.
Lordship, can you grant me 4 weeks' time to obtain the instruction?
That was the prayer met last time also.
Notice was issued.
No, you go through the order 14, 12,
Yes,
20,
yes.
22.
Yes, notice was issued on that day, Lordship.
Oh, notice was issued. Mr. Kiangami, the learned public prosecutor, seeks adjournment of the case after 2 weeks, so as to enable him to obtain necessary instructions.
Lordship, 4 weeks, Lordship.
No, listed accordingly. You can mention after 2 weeks.
For orders, IA Criminal 8, 2022.
By the order dated 7/12/2022, the applicants were allowed to take fresh steps for service of notice on the sole respondent by dusty service through the registry of this court within a period of 1 week. And the affidavit to this effect was to be filed. Office note dated 7/12/2023 shows that the affidavit regarding service of notice upon the respondent by Dusty has not been filed. Stop. Neither is the counsel for the applicant present. Listed after 2 weeks. On which date? The learned counsel for the applicant. On which date the learned counsel for the applicant shall comply with the order dated 7/12/2022.
Item 9, IA Criminal 19/2022.
Your Lordship, here also I'm appearing on behalf of ASO, Your Lordship.
Yes,
So kindly this matter be listed after 2 weeks.
Mr. So-and-so makes a mention on behalf of Mr. Azo, the learned counsel for the applicant, and seeks adjournment of the case after 2 weeks. Prayer is allowed, listed accordingly.
Much obliged, Your Lord.
Item 10 and 11, IA Criminal 21/2022.
May it please your lordship, I'm appearing on behalf of the counsel for the appellant. Since the leading counsel is in this post, if the matter be listed up 3 weeks.
Okay. MS so-and-so submits that Mr. Cynthia Amar, the leading counsel, is indisposed. Listed after 3 weeks.
Much obliged, your
For
lordship.
hearing, item 15, Criminal Appeal Jail 3/2020.
Yes. Yes.
May I please, your lordships? This has come to me on a reference from the State Legal Services Authority, lordship.
Okay.
And there was a delay of about 380 days in filing the appeal. That has been condoned.
Yes.
This appeal is filed under section 374, clause 2 and 375, clause P of CRPC, lordships, against the judgment dated 2012-2018, passed by the Session Judge Oka, convicting the accused under section 376 and 302. And the sentence was 7 years RI under section 376 IPC, and imprisonment for life and a fine of rupees 50,000.
Where is the impugned judgment?
Impugned judgment is at page 80 of the paperwork, lordships.
Page?
80 of the paperwork, lordship. The appeal is filed only on the limited ground because of the fact that the accused has pleaded guilty. And when there is guilty is pleaded, then under section 375, no appeal lies. So only under quantum, the appeal has been filed, lordship, for reduction of the sentence.
When he has actually pleaded guilty and when the impugned order has been passed, whether that avenue is available to you?
That is the reason why, lordships, under 375, there is a bar. Therefore, under clause P, this has been filed.
Let's see the provision. CRPC.
374 clause 2 is appeal from convictions. And then 375,
374. Let's see, just wait.
yes. 374 clause 2. The first one.
374.
Mr. Lordship's got it. 374 clause 2. Any person convicted of a trial held by a sitting judge or an additional sitting judge, or on a trial held by any other court in which a sentence of imprisonment for more than 7 years has been passed against him or against any other person convicted at the same trial may appeal to the High Court. So this appeal has been filed. One of the provisions is under section 374 clause 2.
And what is the provision? What is the other provision? Which is my page?
375. The other provision is 375 clause 2. May I read 375? No appeal in certain cases when accused pleads guilty are cases coming under this. Notwithstanding anything contained in section 374, where an accused person has pleaded guilty and has been convicted on such plea, there shall be no appeal. However, Lordship, clause P, if conviction is by a court of session, metropolitan magistrate, or magistrate of the first class or second class, except as to the extent or legality of the sentence. Only on this limited grounds, Lordships, the present appeal has been filed in view of the fact that accused has pleaded guilty. In the trial court, the legal aid has entrusted one of our colleagues, that is Oren Hamchoi. He has conducted the case on behalf of the accused.
No. So he can on this, no? He can regarding the sentence with its legal extent.
I think you have to note down.
Okay.
Okay. So what was the sentence?
Sentence was 7 years array, and then that is under section 376, and life imprisonment under 302 with a fine of rupees 50,000. That was the sentence.
So for the offense of rape and murder.
Yes.
It's a heinous.
Yes.
Then
Can
what
we
is it?
come to the judgment, Lordship?
Sentence is imprisonment for life anyways. So I don't know what ground is coming anyway. You can put remission in the beginning.
Pardon?
You can sort of come to the court to apply remission. Double the custody.
You can do that. You can do that. Proceed.
Oh. Anyway, let him.
That was not properly observed. And in our case also, it was not sent for forensic examination. Clearly, there is a finding. Of course, the co-accused.
No, all those things becomes immaterial when you have actually admitted your guilt.
Admitted. So, Lordships, I would like to.
So the only question is whether this court can consider
in a similar
reduction of
case
the
also,
sentence.
where the accused has admitted his guilt, this honorable court has quashed.
But actually, maybe in that case, the plea of guilt was challenged.
No.
In that case, whether the plea of guilt was challenged. Here you are not challenging the plea of guilt. See, you are not challenging the plea of guilt. You are only coming before this court with a prayer to reduce the sentence.
Yes.
So you have not challenged the plea of guilt.
Yes.
Maybe in that case, the plea of guilt was challenged.
There is already a bar. That is why I have not challenged.
That is why what madam is saying is that I think if you want reduction, then you will have to come with proper case laws, at least to satisfy this court.
May I cite one judgment, Lordship, which was passed in a similar case? 2022, 2 JLT,
2022.
2 JLT, 707. It's a short judgment, Lordship, so
Yes.
may I read, Lordship, the entire judgment? It's a case from Gokchung, Lordships. Relevant, the judgment starts from page 708.
It starts from
708. May I read, Lordships? Paragraph, from paragraph 11.
para 11. So this will be 709.
From paragraph 11 to paragraph 15 and 18 to 24.
Now,
Only
that's
2
why,
pages.
yes, learned senior counsel. That's why I am actually putting a question. Whether in this case, the plea of guilt was challenged or not. Because in your case, you are not challenging the plea of guilt. So in this case, whether the plea of guilt was challenged before this court. That is the issue. That is the difference. Because what I see is the plea of guilt was challenged. So that's why, whether this will be relevant to your case, when you have not challenged the plea of guilt, and you are only coming before this court to reduce the contempt.
Yes.
So we want you to satisfy us on that.
If you want to reduce the terms of sentence, why don't you go for remission before the court under? See, there's a provision for to remit the sentence. That is 432
Yes.
CRPC.
You can always approach the government under that section. I think that will be best for you. Because here, without challenging the plea of guilt,
Lordships.
maybe it will be very difficult for us. Unless, as we have expressed, unless you give us a very good citation.
Let me reconsider the other options.
Yes, please.
Next date. See, 302 minimum is life. Life has been the
Gotcha.
376, 7 years. How can we reduce that? You see, legality of sentence will be supposing the maximum is so and so, and the court had sentenced him more than the maximum term prescribed. Then the legality, question of legality of the sentence will come.
Correct.
Yeah. What grounds do you have? You want it to be reduced? Then there's a provision, CRPC, for remission.
Lordship.
You can go by that.
Let me take another chance.
Yes, Mr. City, I think you will have to think it over because you are not coming before this court challenging the plea of guilt.
Yes. I have not challenged.
Yes, and as Madam has expressed, that if you have been sentenced under 376 and 302, I think the sentence,
In both
the
the counts,
conviction,
the minimum,
yes, is what is
sentence
prescribed
was-
by law.
yes.
So beyond what is prescribed by law, maybe we cannot go beyond it. So you think over.
Lordship.
If not, I think
Let me withdraw this appeal and then take another chance.
yes, I think you withdraw this and then you take a chance for
Lordships.
approaching the government. Okay?
Lordships.
Mr. C.T. Jamir, the learned senior counsel for the
Accused. Main accused, Lordship.
accused, for the
Accused.
appellant accused,
Yes.
for the appellant accused, and Mr. K. Angami, the learned public prosecutor. Stop. In the course of the hearing, Mr. C.T. Jamia, the learned senior government, expresses that he may be allowed to withdraw the appeal with liberty, we will give, with liberty to file afresh. Prayer is allowed. Writ petition is allowed to be withdrawn with liberty to file afresh. Okay.